Well, members of the Commission, thank you for the invitation to address you this morning. In my dozen years of civil rights litigation and the practice that I've had the privilege, the sincere privilege, of representing students just like the ones you've heard from this morning, more of whom you'll hear from this afternoon. In their stories, you hear the many benefits of religious liberty, as well as the burdens wrought upon real people, real children, when religious liberty is denied by school officials. These students, as you've heard from, joined others like John Rainey, who was told by his principal in Long Island that his attempt to form a religious club at his school was, and I'm quoting, illegal. Mackenzie Frazier, her teacher told her that she could not reference John 3:16 as a part of her class assignment called All About Me. Giovanni Rubio, in the 5th grade, had received a free Bible from his church and during the free reading time at school chose to read it, but was told that he could not do so. And then just last month, Sabrina Stevens, who had to threaten a lawsuit in order to paint a Bible verse on her senior parking space in the parking lot of her New York school. The list could go on for some length of time. Each of these cases represents students from elementary to high school facing situations the Constitution guaranteed them that they should never have to face. And rather than uphold these guarantees, too often school districts weaponize the Establishment Clause against them. And instead of recognizing the demands of the Equal Access Act that religious students be given the opportunity to form religious clubs in the same way that secular clubs may meet, school officials labeled our clients as lawbreakers. Even though the First Amendment guarantees the right of parents to direct their children's education and religious upbringing without government interference, school officials far too often place obstacles in the way of parents having a say in such things after they drop them off in the school drop-off line. For instance, in Ohio, some school districts grudgingly complied with state law that allows parents to send their children off campus to receive religious education during the school day. This is an accommodation that the Supreme Court of the United States upheld in 1952, and they said that it reflects, quote, the best of our traditions when the school accommodates parents to have their children receive religious instruction. But some school districts mandated by state law to allow this very release time religious instruction simply banned such programs from sending back handouts with Bibles with the students to the school when they resume their school day. Yet federal law requires that public schools certify compliance with the Constitution's guarantees on matters of religious liberty in order to receive federal funding under the Elementary and Secondary Education Act of 1965. Well, these are the stories. Let me turn from stories to specific proposals that this commission might consider to further strengthen this nation's commitment to religious liberty. First of all, this commission should recommend that the federal government publicly report which states are compliant in the protection of religious liberty at school, and importantly, which ones are not. Even through the Elementary and Secondary Education Act of 1965, even though it requires state and local educational agencies to certify compliance with the Constitution's guarantees, including religious liberty, within our public schools, the public has no transparent means by which they can know for certain who is and who is not compliant, and therefore who is and who is not entitled to their taxpayer dollars under the ESEA. A very simple website created by the government reporting who has or who has not so certified would give much confidence to parents and students across the country, knowing that their rights will be respected. Secondly, I would encourage you and encourage the rest of the federal government to extend the protections of the Equal Access Act to elementary students and tie compliance with it to funding under the ESEA. The Equal Access Act has prevented many school districts from denying student religious clubs, but only for those clubs for students typically between the grades of 6 and 12. Elementary students like Valerie and others like those that you'll hear from today, they're equally entitled to the law's protections and yet are specifically excluded under the Equal Access Act. And state and local educational agencies should be required to certify that they have complied and will comply with the Equal Access Act in order to receive taxpayer funding. The American taxpayer should not be required to fund schools that welcome secular clubs on campus but are unwilling to allow students of any age to form clubs related to their faith tradition. Third, and finally, celebrate. Provide clear guidance on and rigorously enforce the protections regained in such cases as Kennedy versus Bremerton, Carson versus Macon, and most recently Mahmoud versus Taylor, among many other important decisions of the Supreme Court of the United States that protect religious liberty. Each of these cases restored rights, hear me again to say, restored rights to students, teachers, and parents that were long laid aside under past erroneous and, as we now understand, damaging interpretations of the Constitution. These cases overturned harmful precedents that caused the denial of the many protections of rights flowing from the First Amendment, and also led to students, parents, and teachers being ridiculed, singled out, and ostracized for their religious convictions. The promise of our Constitution applies to the students of our nation's public schools at every level. That, and I'm quoting again from the Supreme Court, that charter of rights that is the Constitution extends respectfully to parents whose right and privilege it is to direct the religious upbringing of their children. Protecting and, where necessary, restoring those rights should be the goal of this commission. As was said many years ago by the Supreme Court of the United States, the students of our nation's public schools do not shed their constitutional rights at the schoolhouse gate. Neither are our nation's schools to be enclaves of totalitarianism. Rather, as another court has said, under the Constitution, school officials may not confine speech, religious speech, to whispers or banish it to broom closets. For if it did, and again quoting from that same court, the exercise of one's religion would not be free at all. Thank you for my opportunity to address you. After we've had some other speakers and perhaps even some lunch, I'm happy to take your questions.